Hello everyone and welcome to Uncivil Law. For today's case, we have the case of Amy Harnishfeger versus United States of America. In this case, Amy was a member of the AmeriCorps, a voluntary organization that allows people to give time to work in the United States to help cure poverty and other related things. Very good for her. However, in a former life, she was a phone sex operator, and she wrote a book telling her tales of her time as a phone sex operator. Her employer, a government agency, found out about her prior work and fired her because of it. In this case, we're learning whether or not she was properly fired or whether or not this was a case of retaliation for First Amendment conduct. So let's read on. This appeal deals with the First Amendment protection for public employees when they engage in speech that is not related or tied to their work. Plaintiff Amy Harnishfeger authored a short book published under a pseudonym about her time as a phone sex operator called Conversations with Monsters: 5 Chilling, Depraved, and Deviant Phone Sex Conversations. A month after publishing Conversations, Harnishfeger began what was to be a one-year stint with the Indiana Army National Guard as a member of the Volunteers in Service to America's VISTA program, a federal anti-poverty program administered by the Corporation for National and Community Services. But when Harnishfeger's National Guard supervisor discovered Conversations and identified her as its author, she demanded that the CNS remove the employee from the position. Harnishfeger filed this suit alleging violations of her rights under the First Amendment and under the Administrative Procedures Act. The district court granted the defendant's motion for summary judgment. Harnishfeger appeals. We reverse in part and affirm in part. Conversations with Monsters is clearly protected speech, and on this record, a jury could find the National Guard supervisor, Lieutenant Colonel Lisa Koplinski, infringed her free speech rights by removing her placement because of it. With that description out of the way, let's read a little bit more about her time in her former line of employment. A little more than a decade ago, Harnishfeger found herself unemployed and disgruntled with the thought of working for the man any longer, as she wrote in the introduction to Conversations. She decided to try phone sex work, but quickly discovered it was not the flirty fun the phone sex industry held it out to be. Harnishfeger was horrified to hear what some of the callers would fantasize to her about, including abuse of minors. These vile, unrepentant, disgusting, poor excuses for men and one woman are the monsters of whom she wrote in Conversations. Harnishfeger did not mince words. If you're having pleasure at the thought of a child, there's something clearly unfit for you in this world, and you need to end things once and for all. Conversations recounted 5 of the most horrifying phone sex calls and meditated on the social role of phone sex operators and her own experiences as one of them. Shortly after publishing Conversation with Monsters, Harnishfeger was selected to participate in the VISTA program. The VISTA program is part of AmeriCorps, a federal network of hundreds of programs across the nation. It is sometimes called the Domestic Peace Corps. Harnishfeger applied to and was accepted as a VISTA volunteer sponsored by the Indiana Army National Guard. Harnishfeger was responsible for maintaining a database of information on service providers to whom veterans and their families could turn to for help. Occasionally, perhaps a dozen times over the course of 3 months, Harnishfeger was unable to find an item of information she needed, such as a service provider's telephone number or a physical address. In 2 such cases, Harnishfeger could find no contact information for the service provider at all, so using her own Facebook account, she posted a comment to the provider's Facebook page asking them for information that she needed. During her 3 months with the VISTA service with the Guard, these dozen contacts were the only occasions on which Harnishfeger interacted with members of the public on the Guard's behalf. Otherwise, she sat at a computer and entered data. So here, the protagonist of our story is collecting information for veterans on various services that are available. So her job is going forth and trying to find the information on all the services and consolidating them in one nice directory that people can find, so it makes it easier for them to find help. That's really good. and occasionally she found it very hard to find contact information for them. So as part of her duties, she would contact them directly, and on at least 2 occasions used her own Facebook page to send them messages to find out contact information for them. So good idea, but unfortunately that is going to expose her underlying previous work, as we're going to soon see. Jason, I refuse to call her Bob. We are calling her whatever version of her name is that I come up with on the fly, which need not be consistent from one pronunciation to the other in any way. So, I mean, I could call her Amy since that's her name, but that'd make it way too easy. We don't do that here. We badly mispronounce names. It's part of the fun. That likely would have been the story of Harnishfeger's entire year with the Guard, but then Noelle Butler, Harnishfeger's direct supervisor, asked to become her Facebook friend. Harnishfeger felt that she could not reject this request from her quasi-employer. She accepted Butler's friend request and thereby gave Butler access to all of her friends-only Facebook activity. Harnish like harness with an ish. Harnish followed by Feiger. Feiger? Harnishfeger? 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 That sounds right, Dustin. Damn it. Now I have to pronounce her name correctly. Harnishfeger? Damn it. I should ban Dustin. Shit. Butler explored Harnishfeger. Butler explored Harnishfeger's Facebook history deeply enough through many dozens, if not hundreds of posts to come upon her June 2nd announcement of the publication of Conversation with Monsters. Over her lunch break one day, out of curiosity about this bizarre title, Butler and another Guard employee followed the Amazon link and purchased a copy of the book. On September the 27th, Butler and the other employee brought the book's content to the attention of Lieutenant Colonel Kopsinak, the Guard's family program director. Kopsinak? Whatever. Lieutenant Colonel Kopsinak wrote a letter to Amy Kublowski. Okay. Oh, man. All right. Oh. Breathe deep, Kurt. Breathe deep. Okay. Lieutenant Colonel Kopsiak wrote a letter to Amy Kublowski, a state program officer. Kopsiak requested that Harnishfeger be removed from the VISTA placement or terminated for early cause. Referring to conversations, Kopsiak explained that the activities and conduct found on Harnishfeger's Facebook page did not favorably represent the Guard's family program office. Harnishfeger contacted 5 of 22 potential sponsors for her. One responded, but it was far too from Indiana to be feasible on Harnishfeger's limited means. Harnishfeger thus failed to secure reassignment by a deadline. On that day, she received a second letter from Lopez informing her that her VISTA membership had been finally terminated for lack of a suitable assignment. Just FYI, guys, are you having more fun now that I actually know how to pronounce Harnishfeger? Are you having more fun now that I actually can pronounce it correctly? Is this better for you? Anyways, so we see what happened here. She was part of a program, and to be in the program, she had to have employment. She was part of this Indiana Guard in order to provide assistance to veterans. Her employer, who is a member of the Guard, a lieutenant colonel, fired her because of her prior work. And because of her prior work that was now exposed, she was unable to find any other employment in this program and so was terminated from the program. The requisite issue here is whether or not she was justly fired, whether or not her employer, a public entity, can fire her for her private speech. Let's read on. Harnishfeger sued Lopez, Kurbowitz, Kopsiak, and Butler in their personal and official capacities, as well as the United States government, for violating her rights under the First and 14th Amendment and the Administrative Procedures Act. To prove a First Amendment retaliation claim, a public employee must establish 3 elements. First, that she engaged in constitutionally protected speech. Second, that she suffered a deprivation likely to deter protected speech. And third, that her protected speech was a motivating factor in the deprivation, and ultimately, if a public employer cannot show it would have inflicted for deprivation anyway, the but-for cause. The first element, constitutionally protected speech, is the nub of this appeal. The second and third are uncontested as to Kopsniak. Whether a public employee's speech is constitutionally protected is a question of law, even though it may require predicate factual determinations. For clarity, we note constitutionally protected speech has two different meanings in this doctrine. A public employee ultimately satisfies the protected speech element of a retaliation claim by prevailing in a balance of the employer and employee interests required by Pickering versus Board of Education, 1968. So, as you would expect, this issue has come up before, when a public employer can fire an individual for conduct that is First Amendment protected or perhaps not, depending on the context. And the issue is there's legitimate interest from the state, but there's also legitimate interest from the individual in not being discriminated by the state on behalf of their First Amendment interests. So there is a balancing test, as announced in Pickering versus Board of Education, that balances these twin concerns, and so we're going to read a little bit more about this. The key issue under our precedent of NTEU are whether the employee's speech is made outside the workplace, involves content largely unrelated to government employment, and is addressed to a public audience, or if it amounts to the same thing, involves any matter for which there is potentially a public. So the first issue is whether it's made in the context of being an employee at work or concerning work matters, or on the other hand, is outside of work, concerns private matters, does not concern work. So that's the first issue of delineation. NTEU offers an easier and clear path to our decision. Harnishfeger's book was written and published a month before she began her VISTA service. Its content is completely and entirely unrelated to CNSC, VISTA, and the Guard. It was written for general audiences on personal experiences of sex workers and their social role, matters for which there's undoubtedly a public. Defendants tried to distinguish the case of NTU by citing a case called Roe. What are the facts of this other case, Roe? The plaintiff in Roe was a San Diego police officer who sold videos of himself on an online marketplace, stripping and pleasing himself in a police uniform and pantomiming police work. For these actions and for failing to comply with the resulting investigation, Roe was fired. Police officer in police uniform selling videos of himself conducting self-pleasing activities for money. Seems like something the government might take some note of, yes. Although Roe's expression purported to be unrelated to his employment, Roe himself had taken deliberate steps to link his videos to his police work, all in ways that were injurious to his employer. The court pointed to the use of his police uniform in his performances, his elusive username, his disclosure of law enforcement employment, and his debased parody of an officer performing indecent acts while in the course of official duties. In finding that Roe's expression brought the mission of the employer and professionalism of its officers into serious disrepute. Put differently, Roe's expression was widely broadcast, linked to his official status as a police officer, and designed to exploit his employer's image. The point of the case of Roe is that a speaker's employee cannot deliberately trade on public employment while claiming the speech is entirely unrelated. But NTEU would mean little if its protections could be circumvented by merely identifying the author as a public employee. So one of the lines of delineation here is that your conduct or your speech is hard to claim. On the one hand, it's purely private, and on the other hand, explicitly tie it to your employment as part of a public servant. You know, you can't really have it both ways at the same time. So if you are saying that you are, in the case of Roe, for example, you're saying that you're a police officer wearing the accoutrements of a police uniform and performing things using police pantomime, then, then your employer, the police, have a legitimate interest in that because you're making your employer look bad using the mechanisms of your office. So you're using your office to further your private speech, and, they have an interest in that. So that's, you can't do that. If you're a public employee, you can't trade on your name in your private speech. If you could, for example, not mention that you're a public employee. You could not, in your videos, mention that, and then, that would be helpful. And you cannot wear the uniform of the public employee, that would be helpful. So, that's one of the things. If you tie it to your employment, your employer has an interest. Conversations was speech on a matter of public concern within the meaning of NTEU, and Harnishfeger is therefore entitled to the Pickering balancing test. The district court erred in reaching the contrary conclusion. That is not enough to resolve this appeal, however, as the district court ruled in the alternative that, even assuming conversations was constitutionally protected in the threshold sense, the Pickering balance weighed in the defendant's favor. This ruling, too, was erroneous. The challenge in public employment speech doctrine is to arrive at a balance between interests of the employee as a citizen in commentating upon matters of public concern and the interests of the state as an employer in promoting the efficiency of public services it performs through its employments. In deciding whether the balance should be struck in favor of speech or efficiency, we have examined 7 factors. So now we're getting into the balancing test. Assuming that there is a legitimate interest from the state, where is the balance between the two? And there's a multi-factor balancing test. So let's discuss. Whether the speech would create problems in maintaining discipline or harmony among co-workers, whether the employment relationship is one in which personal loyalty and confidence are necessary, whether the speech impeded the employee's ability to perform her responsibilities, the time, place, and manner of the speech, the context in which the underlying dispute arose, whether the manner was one in which debate was vital to inform decision-making, and whether the speaker should be regarded as a member of the general public. At trial, the public employer has the burden of showing by preponderance of the evidence that the balance weighs in its favor. Kopinski's first reason for doubting Harnishfeger's effectiveness was that conversations reflected poorly on the guard, but there's no evidence or reasonable inference that it had done so or would have done so, certainly not to the extent that it would risk compromising the guard's mission. So here, the speech would not compromise the mission because it was not related to, was not tied to, and otherwise was completely disconnected from her employment status. So there was no fear of it undermining the mission of the employer. In this case, there is no evidence and no basis for believing that veterans or organizations serving them would distrust the Guard if a known author of a phone sex memoir were permitted to collect and enter the organization's contact information into a database on the Guard's behalf. It is in fact highly unlikely that conversations could have reflected anything at all about the Guard, positive or negative. In sum, the defendant's side of the Pickering balance is empty. The connection between the stated grounds for Harnishfeger's termination and the evidence before us is so tenuous as to support a reasonable inference that the former were merely pretexts for feelings of embarrassment and disgust that conversations undoubtedly and intentionally, Harnishfeger pointed out, aroused in its readers. Nice choice of the word aroused in this context, but okay, thank you, court, for playing. But a public employer may not use authority over employees to silence discord, not because it hampers public functions, but simply because superiors disagree with the content of the employee's speech. So that is the end of the case of Amy Harnishfeger versus United States of America. In this case, we learned that Amy was a public employee as part of the government program for AmeriCorps, and that she was participating in helping collect data for veterans for various programs and such that they could rely on. However, her employer, the National Guard, found out about her prior work as a phone sex operator and fired her because of her speech in her book. The Court of Appeals is noting here that the conduct in question did not concern her employer, did not involve her employer, did not implicate her employer, and was otherwise untied to the mission of the employment, and so there was not a valid reason to fire her because this would fall into the context of protected First Amendment speech in the balancing interest that we saw about, and that is the end of this case.